Thanks for being with us today. I'm Professor Bobby Chesney of the University of Texas, and I serve here as the director of UT's Strauss Center for International Security and Law. My guest today is Professor Matt Waxman of Columbia University, who directs Columbia's National Security Law program. This lecture that Matt's about to give is the first in a series of 3 that he will give regarding the United States Constitution and war powers. All 3 of these are part of a larger series of lectures on national security law sponsored jointly by the National Security Law program at Columbia that Matt runs and the Strauss Center at UT that I run. This series is going to grow over time to include a wide array of topics, and all of it's designed to be helpful to newcomers and experienced hands equally. We hope students will find them especially helpful. We encourage faculty to use these as assignments or as supplemental materials if they think that it might help their students. We'll soon create an online resource that will curate these videos in an easy to browse, easy to access way. At any rate, we hope you enjoyed today's discussion of the Constitution and War Powers with Professor Waxman. Matt's probably well known to most of you already. In addition to his faculty position at Columbia, he's an adjunct senior fellow for law and foreign policy at the Council on Foreign Relations. Matt's held senior positions at the Department of Defense, the National Security Council, and the State Department. He writes frequently about the Constitution and war powers. He has a great recent series at Lawfare. Matt, the floor is yours.
Great. Thanks very much, Bobby, and thanks to the Strauss Center for hosting me. Let me go ahead and share my screen here. Oops. Great. Do you all see my slides?
We've got the, there it is. Yeah, the full view is now available.
The cover slide. Great.
Yep.
So thanks. Today I want to talk about foundations of constitutional war powers. I want to spend some time on this issue, not just because it's important as a matter of constitutional history, but because even today, more than 2 centuries later, appeals to the founding are still such a big part of our contemporary debates about war powers, about uses of force. And so this is really the first of 3 lectures, as Bobby says. Today we'll talk about foundations and the founding and war powers. The second lecture will talk about the evolution and current state of law and practice regarding going to war, initiation of war, or who decides whether the United States uses military force. And then the third will be about waging war. How does the Constitution allocate power over how war is waged, what powers the government has to wage them, and it is hoped to win wars. So in this lecture, I hope to do 3 things. I want to talk about constitutional prehistory, what happened in the lead up to the Constitutional Convention to influence it, and I hope to show how that constitutional prehistory, including some big debates about what lessons to draw from that history, including the Revolutionary War, how that constitutional prehistory influenced constitutional drafting. Then we'll talk about constitutional text and do a close reading of that text. I hope there to show that the Constitution actually has a lot more to say about war powers than is often supposed by many. And then I'll end with some discussion of early tests. How well did the system of war powers actually work in some of the earliest conflicts or security crises? And there, my main point is to show that constitutional war powers got off to a pretty rocky start, and they contain some bigger gaps or ambiguities in constitutional text that were evident right from the start than I think is often supposed. So let me start with, this is one of my favorite paintings of George Washington that captures some important themes of constitutional prehistory. This is a painting by John Trumbull of George Washington before the Continental Congress at the end of the Revolutionary War, resigning his commission as commander-in-chief of the Revolutionary Army. And you know, the experience of the Revolutionary War was very important to the drafting of the Constitution a few years later, though, as I'll get into, many of the drafters and ratifiers of the Constitution drew some conflicting lessons from that experience. What were the lessons of the Revolutionary War? And as a result of some of those debates, there are some compromises that get baked into the Constitution. So what were some of the most important debates, some of the most important assumptions of the founders when it comes to constitutional war powers? What was on their mind? And in particular, I want to focus on two of them, or two baskets of issues. One, what were the security threats that they were most worried about at the founding? And two, what kinds of military power, what kinds of defense forces did the founders think were necessary or might later become necessary to deal with those security threats? So first, as to the security threats themselves, the founding generation had to confront looming security threats on all sides. We were surrounded by security threats. Defeating the British in the Revolutionary War, defeating the British Empire resulted at first in a wave of public confidence. We'd taken on the world's greatest empire and won, or at least fought to a draw and forced the British to withdraw. But Americans in the Revolution had also forfeited the empire's protection. The Atlantic Ocean over here to the east helped shield from that direction the new United States from the great European armies, almost like a giant moat. And the United States also had vast natural resources to draw on. But there were big debates about just how protective that giant oceanic moat would be. The new American government, or really 13 governments at first, was born impoverished and still surrounded by dangers and potential predators. You had the British still to the north and at sea. You had the Spanish to the south, the British and the French in the West Indies or the Caribbean, and Native American Indians along the south and western frontiers. Those were external threats. Internally, the new confederation of states also needed to preserve domestic order and even prevent fighting among the states. So a lot of security concerns to worry about, a lot of security concerns to deal with. So what kinds of defense forces were needed? And by the way, I should just as a caveat say, in describing those threats, the Native American Indians were sort of somewhere in between an external threat and an internal threat because of the position that they occupied within the borders of American territory, but not yet brought within within the sort of the new structures of the United States. So what kind of forces did the United States need to wage, to deal with these threats? A big debate running through the founding was whether defensive needs were better addressed by heavy reliance on individual state militias or by building standing national military forces, especially a national army, but also a national navy. Militias were very much a part of the tradition in each state. Every state had one. Most able-bodied men trained and served part-time in local militias, which required them to arm themselves, to enroll and train in local units, and to prepare to defend defend their territory. And many of the founding generation also feared standing armies. They associated them with British colonial repression. Those who look to history also associated standing armies with tyranny and also a proclivity toward war. On the other hand, many other founders, including George Washington, and especially I would say those who were most involved in actually waging the Revolutionary War in the field, they thought that a regular standing army and a standing navy were necessary. Their lesson of experience was that the state militias were ineffective in the Revolutionary War. They've been ineffective in earlier conflicts under British rule, and that some standing army, some standing national army was going to be necessary. So a big debate about defensive forces, what kind of military forces we'd need, a big debate between reliance on militias and building of standing national forces. And keep that debate in mind when we get to the constitutional text in a few moments. Today, constitutional war powers debates are mostly about foreign policy, right? They're mostly about how do we use military force abroad and what kind of foreign policy harms or benefits come from that. To the founders, war powers were very much about domestic governance. And for them, foreign policy and domestic concerns were very, very much entwined. Many of the founders wanted to check government's inclination towards war, not only because they were concerned about the diplomatic or security dangers of military adventurism or provocations, which we might think of as like the external risks of war powers, but also because they feared the internal effects of war. Many feared that war would lead to centralization of power, especially in the executive, and that this might lead to tyranny. Other founders, such as Alexander Hamilton, took a different view. They said, true, war results in the centralization of power, but liberty can't survive unless the government ensures some adequate national defense in the first place. And so on both sides of that debate, thinking about constitutional war powers was very much about domestic governance, not just about, it was not just a foreign policy problem. So most of you, as we move on to what does the Constitution actually say about war and military power, most of you are probably familiar with this allocation of power. And don't strain your eyes to read this if it's small, because I'm going to, in a moment, blow up the size of the text. But most of you are probably familiar with the idea that in Article 1, which is about Congress, Congress is given the power to declare war. And in Article 2, which is about the presidency or the executive branch, the president is made commander-in-chief. This is, I would say, only a very, very small part of what the Constitution actually says about war. Again, don't strain your eyes. I'm going to go through this in more detail, but I put this up, and this isn't even all of it. The Constitution is not a long document, and in it, it has a lot to say about military power, and some parts of it are much more detailed about military power than they are about other aspects of constitutional allocation of powers. Before going into some of the specific provisions, and I want to start with Congress, let me make two general points about Congress that are not on this slide. First, keep in mind that Congress is constructed by design to be slow and cumbersome, right? In order to enact legislation, two houses of Congress, each according to their own rules, need to adopt legislation before it even goes to the president for signature. So stuff that Congress does is going to be done slowly, and it's hoped after thorough deliberation. Second is, in addition to the specific war powers provisions that I'll get into in a moment, Congress has a general power of the purse. And that's important because military power is expensive. It was a huge, it remains and was a huge national government expense. And this also means that Congress could serve as a check on military power by denying funds. And I'll talk in subsequent lectures about what happens to that check over time. But with those general points in mind, let's start to unpack and look specifically at some of the specific provisions related to Congress's war powers. The Declare War Clause actually is, it contains some other clauses within that line. It says that Congress shall have the power to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. Now, there's a lot of debate about what this clause means. That's part of an even bigger debate about which branch, the executive branch or Congress, controls whether we use military force or not. In my view, the historical evidence is really strong. I think overwhelming, that the founders intended for the Constitution, by virtue of this clause, to grant Congress exclusive power to take the nation from peace to full-fledged, to full war. This was a radical departure from European states where monarchs, including the British king, had that power. And the new American system, in a revolutionary way, gave that power to the legislature. Why? Well, many founders, including James Madison, probably the lead drafter of the Constitution or lead architect of it, believed that lodging power to initiate war in Congress would help constrain or restrain impulses toward it, especially impulses by presidents who might be inclined to seek glory and enlarged power as wartime commanders-in-chief. And requiring approval of both houses of Congress placed procedural hurdles in any path towards a decision to wage war. George Mason, the influential convention delegate from Virginia, touted this feature as, quote, clogging decisions on war, at least decisions about full-blown war.
Well, Matt, can I interrupt there to ask you a question? So full-blown war, can you unpack what distinction are you drawing there? Implies there's other kinds of war, and declaring full-blown war. What's the significance of that?
It's a great question. You know, the way I put it is this way: wars today, really since the end of World War II, aren't usually formally declared anymore. The United States hasn't formally declared war since World War II. But in the late 18th century, a declaration of war was a significant international legal idea. It didn't merely signify the opening of armed hostilities, but it also triggered whole bodies of international rules regarding things like the duties and protections of neutral states, the treatment of prisoners, confiscation of enemy property. So a war declaration was not just a decision to use military force, but it also carried a lot of domestic law and international law effects too. Now, your question raises a lot of other very, very important additional questions about this clause, that even if what I said is true, that the founders intended to lodge the power to initiate full-blown war in Congress, exclusively in Congress. This raises a bunch of other really, really important issues. For one thing, although the founders intended to lodge decisions to wage full-blown war in Congress, they probably agreed on what's a pretty sensible exception, that if the United States were attacked, invaded, the president could take some military action in defense. This was especially important in an era where it would have taken weeks for Congress, if it was out of session, to even assemble, from around the country on horse-drawn carriages. So they probably thought the president could respond to, let's say, an invasion and repel it on his own authority. But three other big questions arise. One, could the president use any force unilaterally, perhaps well short of war? What if the president just wanted to defend an American vessel that was being attacked at sea, let's say, or launch a small-scale military operation across U.S. borders? Does he have the power to do so? Two, if the United States was threatened in some way other than a direct military attack, like an invasion, could the president respond unilaterally to that? Did he even have to wait for the attack actually to occur? And three, besides a formal declaration of war, how might Congress authorize war or force? And might that authorization be merely implicit if Congress passes legislation appropriating money for military forces? Is Congress thereby implicitly authorizing the president to take some military action? And those are some big questions that I don't think are clear either. I don't think are clear in the text at all.
Well, Matt, what about,
Yeah.
we have other sources for besides the text. We've got Madison's notes. We have other, well, Madison's notes are most of the time there. These questions you've raised, these are the big money questions very often today. Do those other non-textual period sources give us any insight what the framers thought they were accomplishing on these, or did they just not address these topics?
The short answer is not really. You know, as you say, James Madison has detailed notes from the Constitutional Convention. I think the answers to the questions I've raised here are very unclear. There's very little evidence from the debates about what was intended, especially on use of military force well short of war, or whether Congress could implicitly authorize force. There's essentially no good evidence on that. Sometimes a lot is made of a particular exchange that goes on during the drafting process, where a draft of this clause that originally would have said Congress shall have the power to make war was changed to declare war. And, you know, scholars today debate about what that change meant. Sometimes it's interpreted to mean, well, that was to make clear that that this idea that the president could respond unilaterally if the United States was attacked. I'm reluctant to draw too many conclusions from that one little squib of debate. So the short answer is no. There's very little from the actual convention debates about these kinds of questions, though all three of those issues that I just enumerated come up almost immediately after the Constitution is ratified, and the drafters. I'll get to this at the end of the lecture. The drafters themselves end up splitting along some new partisan lines, because I think they wouldn't have agreed on answers to those questions. So coming back to the text, note that that the clause goes on. It mentions declaring war. It also mentions granting letters of marque and reprisal, and making rules concerning captures on land and water. Letters of marque, these were essentially government licenses to private individuals, so-called privateers, authorizing them to capture enemy vessels that they could then bring into friendly ports and reap profits from them through their sale as so-called prizes of war. In conflicts in that era, this was essentially state licensed piracy. It was a way, an important means of augmenting naval power in wartime. Naval power was really expensive, so this was a useful way of augmenting it. And the last point I'd make on this clause is that the fact that the Constitution speaks so directly about privateering and about legislating rules on captures in the very same clause as it grants the power to declare war, I think, testifies to the importance of commerce, maritime commerce, in early American military thinking, American military strategy. The founders saw protection of American trade as critical to American security, even if they disagreed among themselves about how best to achieve it. So next, this next set of clauses is best read in conjunction with the general powers to tax and spend, the powers of the purse that I mentioned earlier. So having granted Congress the power to declare war, the Constitution goes on to grant Congress the power to create national military forces, to raise and support armies, and to provide and maintain a navy. And the power to fund and create national military forces remedied a major deficiency of the Revolutionary War and the Articles of Confederation, when any national military capability really depended on financial and personnel requisitions from the states. That arrangement of going to the states to send troops, to send funds, that was spotty and slow, and just didn't operate effectively in the Revolutionary War.
Matt, I can't help but observe that the Army Clause and the Navy Clause are not the same.
Exactly.
Draw
exactly.
conclusions as you will. No, seriously.
Yeah, no.
So
that's exactly right. So why is the language different? As to the Army, the power is not merely to create Army forces temporarily in wartime, but to keep them in place. I think the idea of not just raising and supporting them, but perhaps this is written in order to sort of hammer home this idea that these could be standing forces. But that was a controversial idea. I mentioned before how concerned, if not the drafters, then those who were going to be charged or asked to ratify the Constitution, they worried about standing armies. And the drafters therefore added a caveat on the Army Clause that no appropriation of money for the Army shall be used for a longer term than 2 years. Now, 2 years happens to be the term of office for the House of Representatives, and periodic elections mean that the executive branch would continually have to return to Congress in order to keep an army funded. I interpret this as essentially an automatic kill switch, sort of a circuit breaker in case the standing army runs amok. Only Congress can spend money, or only money that Congress appropriates to the Treasury can be spent. And so without any new legislative appropriations, the Army would simply run out of money after 2 years unless Congress replenishes it. There's nothing militarily efficient about this at all. This is a check on military power. And as you observed, Bobby, the power to create and maintain a navy doesn't contain any such caveat. I think this is partly because the founders and the Revolution era public saw armies much more than navies as instruments of political repression or possible political repression. I think the Constitution may also have imposed less restriction on national navy because navies required longer term capital investments. Ships took years to build. Shipyards took years to build. And now, interestingly, I mean, armies also require some big capital projects like fortifications. And the reason I mention that is over time, through a series of attorney general opinions, the Army Clause, that 2-year limitation has been interpreted narrowly, essentially just to apply to troops. And the logic being, that's what the founders were worried about, was standing armies as possible instruments of political repression, but military expenditures for big capital projects could extend beyond 2 years. But I think those are the reasons why you see, as you observed, a difference in the language there. Turning next, basically states can't wage wars on their own. I think that's the main takeaway from this clause here. Note that we usually think about war powers as an issue of horizontal separation of powers between the branches, right? Mostly between the political branches. But the original Constitution also involved vertical separation of powers between the national government and the states. I mean, keep in mind that the biggest overarching debate at the Constitutional Convention was, and the ratification process, was the relative power between a new central government and the states. And war powers contain some important aspects of that big meta debate about national government versus states. And that brings me to the next slide, the militia clauses. So as you see, Congress has the power to provide for calling forth the militia, to execute the laws of the Union, suppress insurrections and repel invasions, then goes on to say that Congress has a power to provide for organizing and arming the militia, but it reserves to the states the appointment of officers and the authority of training the militia according to certain national standards prescribed by Congress. There's a lot going on in these clauses, and they are part of a very big compromise that we don't really think of that much today, but which was a huge deal at the founding. In fact, I'd argue that without this very messy compromise, which again is a very militarily inefficient one, essentially no other state in the world that especially, well, is not one that plans to fight wars would have a constitutional allocation like this. But without this messy compromise, I don't think the Constitution would have been ratified. And let me make a few points here. First, when read, especially in conjunction with the Second Amendment, which we normally think of today in terms of gun rights, but if you read that amendment, I think what the Constitution here was essentially saying state militias pre-exist the Constitution. All states had them, the colonies had them. They are constitutionally protected. The Army and the Navy are optional. Militias are guaranteed, but a national military force is merely discretionary. So that's point number one. Point number two is the national government, Congress specifically, has the power to call state militias into service, but arguably from the text only for certain very specific defensive purposes. It says Congress can call forth the militia to execute the laws of the Union, to suppress insurrections, and to repel invasions. Those are all, I think textually, those all sound like local defensive measures, as opposed to, for example, calling up the militia and sending them abroad. I'll come back to that later on in the lecture. Third is just to note there's a big concession to state power here, which is that states get to appoint, in addition to getting to keep their militias, they get to appoint officers and to train them. Like I said, I don't think the Constitution would have been adopted without these concessions. And a big war powers story over time, in my opinion, is how the federal government essentially absorbs state militias into the national military. And I'll talk about that a little bit at the end of this lecture, but that comes up in the third lecture in this series about how the Constitution regulates the waging of war.
Matt, can I interrupt to ask about the role of Congress here? Because I can imagine a version of this authority in Congress that is very similar to the declare war function, where Congress is looking at the state of the world and from time to time says, oh, okay, we need to exercise our power. And just as in the external setting, they might decide to declare war. Here, they might decide to call forth the militia. Is that how it works? Is it done case by case as the facts change by Congress, or is it different than that?
Yeah, it's a great question, because as you say, a natural reading of this would be that in the event of some sort of emergency, Congress would directly call forth the militia, or say, all right, we are calling the New Jersey militia to come and deal with this insurrection or this particular invasion. Here we really have to look at practice, and the practice in this area begins in the George Washington administration, where Congress exercises this power with a set of militia acts that delegate quite a lot of power, quite a lot of discretion to the president. They essentially say by the following act of Congress, in the event that the following types of emergencies occur, the president shall have the power to call up the militias as he sees fit. So that's quite a broad delegation of power. Delegation of military powers is something I'll come back to later, because there were sort of some conflicting practice or there was a lot of debate about the constitutional propriety of such delegations in the early years of the Republic. That's how it was exercised, though, was through these very early militia acts. And in fact, the first significant military operations by the new United States involved militia that were called up either through the militia acts or through some earlier acts that Congress passed to deal, for example, with security along the western frontier. So Congress authorizes the president to use militia for protecting frontiers against threats from Native American Indians, which Washington does. And I would say that arguably the first conflict in which the United States tests out these new sort of revolutionary war powers under the Constitution is a conflict that really predates ratification, which is the conflict going on, border tensions between settlers and Native American Indian tribes on the western and to some extent the southern frontier. Also, an especially interesting event during the Washington administration is the Whiskey Rebellion, where George Washington calls up a very sizable force, much of it state militias, to march across the Allegheny Mountains in order to put down the Whiskey Rebellion. This is also kind of an interesting first and only in constitutional history, where George Washington, as commander-in-chief, actually gets up on a horse and leads troops at least partway along that journey to Western Pennsylvania. So you actually have the commander-in-chief in the field directing military operations. George Washington kind of has some experience in that area, so kind of natural that he might assume those powers, but probably best that since then that has not been the standard practice for other presidents. Oops, let me turn to now. Whoops, sorry, let me just go back one. Oops. I want to just talk about the necessary and proper clause. This is a generic clause, not specific to military affairs, but I mention it here because at later times in history, it does a lot of work in constitutional war powers, especially as new technologies and new forms of conflict revolutionize what's necessary to win them. I'll talk about that clause, the necessary and proper clause, and what it means for war powers in lecture 3, which is about waging war. So that's most of what I want to talk about in Article 1. Let's talk about Article 2 now. The executive power shall be vested in the President of the United States. The President shall be Commander-in-Chief, ... and he shall take care that the laws be faithfully executed. Here's where the President's war powers are, and note that only the middle one, the president shall be commander-in-chief of the Army and Navy of the United States and the militia when called into service of the United States. I note that only the middle one there, the second one, is self-evidently clearly about war and about military power. The first thing I'll say about it is just to note that the president is always commander-in-chief of the Army and the Navy. It doesn't say that in the event of a declared war, or if Congress authorizes the use of force or something like that, the president is commander-in-chief. He's always the commander-in-chief. A big question is, what the heck does that mean? It seems reasonably clear that it includes being at the top of the operational chain of command, so directing the conduct of military commands, being in charge of overseeing battlefield decisions. It seems reasonably clear that it includes that. But does being commander-in-chief also mean the power to decide to initiate military conflict or to launch military operations or interventions on the president's own initiative? Not at all clear from the text that that's so, but over time, the executive branch has generally interpreted that clause very broadly. Now, one reason why over time, I think we don't really get that much clarity on what does the commander-in-chief clause mean is because it's sandwiched between these other two clauses that also get read as war powers. Again, sort of, it's not self-evident that these are about war or military powers, but over time, the executive branch starts to read the executive power, the vesting clause, and the take care clause as giving the president some emergency powers, or especially in the case of the first one, the executive power, some foreign relations powers to protect the United States, to manage war efforts well beyond the battlefield, and also to initiate military intervention or conflict in the first place. And I'll talk about this in lectures 2 and 3, but a very common executive branch argument that starts early in our history is to sort of lump the three together and say the sort of the amalgam of executive power, commander-in-chief power, and the responsibility to take care that laws be faithfully executed, when combined, give the president a lot of emergency power, a lot of power over military affairs. And so trying to then pry them apart and figure out what does each one mean individually becomes almost impossible over time because they tend to be sort of mushed together that way. Again, those arguments will be the subject of lectures 2 and 3, but the point here is that these clauses in Article 2, I think, are very textually ambiguous, and they're later interpreted very broadly by the executive branch when it comes to matters of war and the military. I just want to back up to one last clause to talk about in Article 1, which was about Congress. This is the provision known as the suspension clause. Ooh, whoops, wrong slide. Oops, sorry. There it is. The suspension clause. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. Now, a few things to note here. It's a very oddly written clause. One reason why it's odd is it talks about suspending the writ of habeas corpus, but nowhere does the Constitution say that you have right to habeas corpus, which for those who don't know is essentially an ancient right dating back to British rule and the British government, a right to petition a court to challenge the legality of one's detention. So the suspension clause assumes that the right exists in the first place. But the reason I think it's especially an oddly written clause, and this causes some problems down the road, is it doesn't actually say which branch may suspend that right. That becomes a big issue in the Civil War when Lincoln unilaterally suspends it. I think when viewed as an element of Article 1, which is all about Congress, I think the best argument is that it was intended for Congress and only Congress to have this right. But there's a very interesting debate in the Civil War about whether under some circumstances, perhaps the president also has the right or the power to suspend the writ of habeas corpus. But to me, the even more interesting aspect of the suspension clause is that when you look at the Constitution as a whole, this provision stands out as the only feature that may explicitly be toggled off during certain war emergencies. The rest of the Constitution operates in wartime and peacetime alike and doesn't have an express provision, an express sort of off switch, emergency switch to just turn it off altogether. Now, to be very clear, the meaning of other provisions may adapt, they may bend or flex in wartime, a lot of them do, but the Constitution doesn't have an explicit mechanism for suspending the other provisions altogether like there is for habeas corpus in certain war or war-like emergencies. And so that's just one reason why I think this stands out as an interesting feature of the Constitution and is different from the Constitution of some other democracies that have sort of more extensive emergency constitution provisions built in. So that's the constitutional text about war and military power, or at least most of it. There are a few other odds and ends, the guarantee clause and the supremacy clause, but you'll see already, I hope, that there's a lot more to the constitutional text than just the declare war clause and the commander-in-chief clause. And at the founding, many of these clauses, other than commander-in-chief and declare war clause, they were crucially important, and we'll see in later lectures that they take on some special importance at some later times in our history. So having talked about the text, I want to, before getting to some concluding points, talk about early practice, because the Constitution was a big experiment in governance generally, and I mentioned before that the new republic faced some serious security threats right off the bat. So how did the system operate in its first big trials? This is important also because despite all the textual provisions that I just outlined, I also pointed out where there are a lot of important ambiguities or important questions that are just not answered in the text. So how did the system operate in its first big trials? Well, the constitutional war powers, I think, got off to a pretty rocky start as the United States encountered its first big security crises. Many of the key assumptions about war and the Constitution turned out to be flawed. Gaps in the Constitution were filled in ways that many of its architects failed to fully anticipate. I think in some cases, they left some gaps deliberately unfilled and wanted them to be filled through practice. So I think some of those ambiguities and some of those gaps were very deliberate by design, but some of them I think were a bit more surprising. So let me just talk about a couple of those early crises and at least some of the questions that were raised in those early tests. So the first one I want to talk about is not a war, not a full-blown war, but is known as the quasi-war with France. So this is during the John Adams administration, when the United States, despite its efforts to maintain neutrality, gets dragged into a European war, largely between Britain and France. And French privateers begin raiding American ships and their cargoes, especially in the Caribbean or West Indies, where so much, an immense amount of American commerce transited at the time. So the resulting quasi-war of 1798 to around 1800 between the United States and France actually involved very few actual battles, almost all of them at sea, but it begins to set some important constitutional precedents. It also raises some important constitutional questions about war powers. And this, to me, is an especially interesting episode because many of the constitutional issues were hotly contested only a decade after the Constitution is drafted. And they're debated by players who themselves had been part of the constitutional founding itself. And so we have, if we're interested in, well, what did the founders think about some of these questions? Well, the founders were members of Congress or members of the administration at this time. And we see that they are in some cases, very bitterly divided on some of these questions. Many war powers questions come up in the quasi-war. I want to just mention four that I think are especially interesting. First, assuming for the sake of argument that the president may not initiate full-blown war unilaterally, what if he takes steps using his other powers, let's say his commander-in-chief powers or his diplomatic powers, that make war more likely, that risk provoking France into a war? I'll talk about what a big issue this is in lecture 2, because I think the president has a lot of power both to deter war, but also to, in some cases, provoke war. And the issue comes up here because President Adams allows the arming of merchant ships against French privateers. And some of his critics are outraged by this, saying, whereas Adams says, look, this is just a prudent defensive measure. We just want to protect these vessels from being preyed upon. Many of his critics charge that this was not just provocatively hostile, but unconstitutionally so, because it risked escalation of the conflict. Like I said, I'll return to this issue, but we begin to see some early practice and some head scratching of, well, how far can the president go in taking actions, perhaps just even what he sees as defensive ones that risk drawing the United States into a war? Second question, in some ways a reverse of the first one. May Congress delegate some of its military powers to the president? This came up earlier in our discussion of the militia clauses and the early militia acts, but this comes up here in the quasi-war with proposals in Congress to give the president some conditional authority to expand the size of the Army or the Navy under certain circumstances in his discretion. And some opponents of those proposals said, wait a minute, the Constitution very deliberately gives Congress and only Congress decision-making about whether to expand the size of the Army and the Navy. So there's some pushback on this. This gets resolved in practice during the opening phases of the quasi-war with a bit of a compromise that what Congress ultimately passes is some conditional delegation to the president where he's authorized to expand the Army and the Navy, but only under certain very narrow conditions laid out by Congress. Over time, by the way, Congress ends up delegating a lot of military powers to the president. Third question, we know that Congress can declare war. We talked about what declaring war meant. But what about authorizing force short of full-blown war? Can Congress do that? And the quasi-war establishes clearly that it can, that Congress may do so. It can authorize force limited to certain places or times, for example, or for certain purposes. And the Supreme Court even weighs in to affirm this idea. I call that out as significant because war powers is an area in which Supreme Court precedent is very sparse. Courts tend to steer clear of many of the biggest war powers questions. So it's not at all uncommon that in executive branch legal opinions, or when there is litigation about these kinds of things, for the government's briefs or litigants' briefs to be looking back to things like the quasi-war as some of the most relevant judicial precedent that we have in this area. The fourth question is sort of a flip side of the third. If Congress authorizes some limited conflict or puts limits on how military force might be used, does that unconstitutionally intrude on the president's powers as commander-in-chief? If the commander-in-chief is meant to be sort of the top military commander, can Congress say, well, okay, you can use force, but only up to this geographic area? For example, here are naval vessels that you can use to protect American commerce, but only in American territorial waters. At what point, if ever, do those restrictions unconstitutionally intrude on the president's constitutional discretion as commander-in-chief to direct how military forces are used? Let me say this is a very, very difficult area of constitutional law. It's one that I'll discuss in lecture 3 about the Constitution and waging war. This is also an area where the Supreme Court does weigh in, and to a limited extent. There is another Supreme Court case from the quasi-war that holds that some restrictions by Congress on how the president may use military force are constitutionally permissible. We'll talk in lecture 3 about how much or how little to draw, how much or how little usefully we can draw from that from that Supreme Court case. Again, though, these early episodes, this early conflict, I think, is important for beginning to fill in some of the details about war powers that are not clear in the text. I'll talk next, and the second major test in practice I want to talk about is the War of 1812. So this is a picture of the rocket's red glare over Fort McHenry in 1814. And the War of 1812 was our first major declared war. It's sometimes called the Second War of Independence or Madison's War. It's significant that the commander-in-chief was, as James Madison, sort of the chief constitutional architect and drafter. The War of 1812 is usually celebrated today as a victory, but it's really a tie, and it's and almost, by the way, a catastrophic defeat. I think there are really two aspects of the constitutional design that didn't work well, and I'd argue that the system of constitutional war powers malfunctioned, almost catastrophically malfunctioned in the War of 1812. I'll mention two of those. The first is, this was our first congressional war declaration, but as I'll detail in lecture 2, which is about war initiation, the war declaration process didn't work well. It did not assure, Congress declared this war, but it didn't, congressional declaration did not assure that war was a last resort. In fact, rather than sort of a war impulsive president rushing into war, if anything, it was the war hawks in Congress that pushed a reluctant president towards war. The war declaration process didn't assure good deliberation about matching means and ends. We were unprepared for this war. We lacked a good war strategy. A war declaration process didn't assure broad support. This was arguably the nation's most divisive war in its history, politically divisive war. It nearly split the country apart. In theory, the declare war clause was supposed to alleviate all those issues. It was supposed to prevent a rush to war, make sure that there was good, thorough deliberation, make sure that war had very deep and broad support, and the war declaration process, I think, failed along all three of those dimensions. The other part of the Constitution that functioned poorly in this war were the militia clauses. For one thing, militia forces themselves functioned poorly in the field. This was no surprise to those who had commanded in the Revolutionary War. But the constitutional relationship between militias and the national government also proved rocky. To begin, it's important to begin this point, it's important to recognize that opposition to the war was especially intense and concentrated in the Northeast. So when the federal government called New England states militias into national service, New England governors initially refused. And throughout the conflict, they dragged their feet in supplying militia forces to the war effort, and each demanded special command arrangements to keep state forces under their own officers. And I'll just go back to the militia clauses here. The militia clauses in their text calls for states to retain control over the officers for their militias. And this was a tool that New England governors used in order to try to maintain some control over how their militia were used in this war. Another way in which the militia arrangement sort of malfunctioned in this first war. A big part of our war strategy early in the conflict was a three-pronged invasion of Canada, ill-conceived plan, by the way, for which we were definitely not prepared. But as one of those prongs was advancing northward in the east, some state militia forces suddenly stopped when they reached the Canadian border. And their claim was, as a matter of the Constitution, we can't be sent. We don't have to. We can't be sent across the border. And if you look back up at the top here, it says militia can be called into use by Congress for in executing the laws of the Union, suppressing insurrection, and repelling invasions. And some northeastern militia forces said that's not an invasion of Canada, invasion of a neighbor isn't on that list. So we cannot constitutionally be compelled to move across the border. I'll talk a bit in lecture 3 about how this problem gets solved with, I think, some pretty crafty lawyering in the early 20th century. So let me just close by saying on the War of 1812, let me close by saying that some compromises on militias that were necessary to assure the Constitution's ratification contributed to some real malfunctions of the American military machinery. I'd also, though, argue at the same time that those compromises worked as sort of pressure valves, and they probably helped hold the Union together in the first major war by allowing states that were very critical of the war to sort of ventilate some of their concerns and even exercise some control, some local control over the war's execution.
Matt, let me ask you a question meant to sort of take us here towards the end to a higher level perspective, but still staying with this early Republic perspective. In particular, I want to ask you about the Federalist Papers. You've identified a variety of elements of the text that are ambiguous. In the American common law tradition, we sure love looking to the Federalist Papers for insights. Do we find any that are helpful there?
Fewer than I would have hoped. The Federalist Papers contain some important explanations and clues relevant to some of these questions. But for starters, it's important to keep in mind that these are essays by Hamilton, Madison, and John Jay that were advocacy pieces, right? These were part of the effort to try to win political support for ratification. Let me make a few points about what they say about war powers. First, the Federalist Papers, while they don't necessarily say a lot about the meaning of some of the specific and most ambiguous clauses that I've talked about today, they say a lot about national defense and security threats. The first, if you look at basically the table of contents of the Federalist Papers, all of the first ones are about national defense. From external threats, from internal threats, about the need for a union that is going to be better able to protect the security of the 13 states than any loose confederation could. Second, the Federalist Papers say a lot to justify Congress's powers to create a standing army. It's important to keep in mind that the Federalist Papers, some of them were written in response to specific essays often under the label of the Anti-Federalist Papers. And a big theme in the Anti-Federalist Papers was opposition to a standing army. They really helped capture, I think, some of the fear of standing armies that permeated a lot of the pre-constitutional American public. It's interesting that Madison in the Federalist Papers says, he really emphasizes how small he thinks the national government will be. He really thinks, in part because we have the militias and because we have that big Atlantic oceanic moat, that we're never going to really need a large standing army. The Federalist Papers say very little about going to war, which emerges as a very big war powers question. There's essentially no direct discussion of that, and almost nothing about what the Commander-in-Chief Clause means. There's a very interesting line in Federalist 69, which is written by Hamilton, where he really downplays what it means to be commander-in-chief. He is, and remember, he's trying to sort of assuage concerns that the Constitution might create the tools of tyranny. And so he's bending over backwards in this essay to say, oh, nothing to fear here with this president as commander-in-chief. The president's going to have not just way less military power than, let's say, the British king, but even less than the governor of New York has when it comes to, the New York militia. And at one point, there's a line there where he says, the commander-in-chief, the clause means nothing more than the president is first general and first admiral. So he's really trying to interpret or say that the commander-in-chief clause is a very narrow one. Now, Hamilton, I think, either didn't believe that truly, or he backs off of that in a hurry, because he generally, certainly in the constitutional debates, but then later especially in the Washington administration, he's a big proponent compared to Madison for strong executive military powers. So I don't think he really believed that the president's powers were just directing forces in the field, or maybe he was being cute with what he means by first general and first admiral. But the bottom line, to get back to your question, is Federalist Papers, I don't think really help with a lot of the questions that I raised as gaps or ambiguities. And again, I think that's partly because these gaps and ambiguities were strategic or intentional. In some cases, they were intentional because the founders just wanted to let practice kind of sort out some of these kinds of questions. In some cases, they were strategic in the way that we have ambiguous or gaps in contracts, because in order to get the deal done, you kind of have to paper over certain differences. If you try to bridge every gap, every disagreement up front, you may never get a deal. So I think some of those gaps are intentional or were expected. Some of them were unexpected. I think I think many of the founders probably thought that war would be more often come in the declared full-blown war variety. And one of the things we see in early practice is that most of our conflicts are not full-blown wars. They're lower scale conflicts, somewhere in this spectrum between peace and war. And so that actually brings me around to some final words, some final concluding points I'll just make here. The Constitution provides for and controls military power in many interlocking ways. That includes horizontal divisions of power, but also vertical ones, not just between the branches, but between the levels of government, the national government and the states. I think what's important about those balances is that they're not just efforts at trying to achieve military expediency, but also baking directly into the Constitution some deliberate inefficiencies, because some founders were concerned that if you build a machine that is too militarily effective, you'll be too tempted to use it. So they deliberately baked some military inefficiencies into the system. Early tests like the one that I've talked about exposed some weaknesses and big questions, but we learned from that experience, and the Constitution, one of its virtues is that I think it proved to be quite adaptive. And so looking ahead, and this is what I'll get into in lectures 2 and 3, big question, how does the Constitution adapt to really vast changes in the nature of warfare and the nature of American grand strategy?
Fantastic. Well, you probably are exhausted, but that was really fun for the rest of us that just got to sit back and enjoy this, Matt. And we hope you're finding this beneficial and that you'll tune in for the wider array of lectures and webinars we're going to create as part of this series. And with that, I'll simply say thank you, Matt Waxman, and thanks to all of you who've been with us. Take care. Bye.
Thank you.